Hello and welcome to Unacademy, India's largest online learning platform. And welcome to Crack CA exams with us. This is the vertical of Unacademy that caters to the students of the CA Foundation, CA Intermediate, and the CA Final Examination in their preparation for the tough CA course. Now, what do you get in Unacademy? You get top educators, you get quality content, and you get great learning experience. So I hope you get all three of them and make use of them to the maximum extent. Come, let's crack the CA exams. Before we go into today's session, a little about the educator today. Hello, I'm Prathik Gupta. I am a Bachelor of Commerce from Christ College, Bangalore University. I am an associate member of the Institute of Chartered Accountants of India. I am also an associate member of the Institute of Cost Accountants of India and an associate member of the Institute of Company Secretaries of India. I am also a law graduate from Karnataka State Law University and am currently a practicing chartered accountant. I am also a visiting faculty in a number of institutes for CA subjects and an educator for CA students offline and online. Prior to starting my own practice, I worked with SR Bartley Boy and Associates, that is the Indian member firm of Ernst & Young Global, that is EY Global, in the audit and assurance department, and Ernst & Young, that is EY India, in the mergers and acquisition department. I also worked with the Manipal Group and was the corporate controller of their Indian and the German entity located in Frankfurt, Germany. It was only after I got back from Frankfurt, Germany that I decided to start something on my own. And here I am today taking a session for you. And I thank you very much for being a part of my session. Unacademy also has a Plus platform, which is a subscription-based platform which provides you various packages. So I urge and encourage all of you to become a part of the Plus platform of Unacademy. Details about the packages and everything will be given to you as we move ahead. All right. So what do you get when you become a part of the Plus platform of Unacademy? First and foremost, you get live daily classes where you get to chat with your educator, engage in discussions, ask your doubts and answer polls. Yes, all this while the class is going on. You do not need to wait for another day or an appointment, and all this can be done as and when you do that. When you have the classes going on, you can clear your doubts, discuss with your educator on a real-time basis. Secondly, when you come onto the Plus platform of Unacademy, you get various live tests and quizzes. Now, in live tests and quizzes, which help you evaluate your preparation with regular mock tests and quizzes and get detailed information about your performance. That is to identify your weak areas, your strong areas and not so strong areas, so that you can prioritize your time and spend more time on your weak areas and spend lesser time on your strong areas. So this is also one of the purpose of the Plus program of Unacademy. The next, you get structured courses on the Plus platform of Unacademy. Structured courses in the sense, all the courses provided on the Plus platform of Unacademy are structured and in line with your exam syllabus to help you best prepare for it. So all the courses on the Plus platform are kept in line and prepared keeping in mind the syllabus of your examination, be it the CA Foundation, be it CA Intermediate or the CA Final Examination. And then once you finish the course on Unacademy Plus platform, you can rest assured that you have completed your syllabus to the maximum extent possible and no important point or topic has been left out. So this takes care of all the courses of your CA Foundation and Intermediate examination. And lastly and most importantly, you get unlimited access. You get the one subscription to the Plus platform of Unacademy gives you access to all the live and recorded courses present in the Unacademy platform to watch from the comfort of any of your devices. Yes, I mean the comfort of your devices. You can view the sessions whenever you want, wherever you are. You do not need to have a special appointment or a place designated to watch it. You can watch it in between whenever you're commuting, whenever you're busy in between meetings, and find even a little bit of time. You can actually go on and watch the sessions. The sessions can either be live or it can be recorded, and all will be provided to you in that one subscription package. So I once again encourage all of you to become a part of the Plus program of Unacademy, which is a subscription-based model, and make the most of it in your preparation for the CA Foundation and Intermediate examination. Let's move further. For those of you who have downloaded and are using the Unacademy Learning app, I thank you very much, and I request your support in the future as well. And for the ones who have not yet downloaded the Unacademy Learning app, I request you to download it from your Play Store and register on it using the OTP which will be sent to your mobile number. The registration on it is quite simple. You enter your mobile number and you get an OTP. Use that OTP and register on the Unacademy Learning app to explore the world of courses, resources and content that Unacademy has to offer you. Now, what happens if you become a part of the Unacademy Learning app? First and foremost, you need not wait to get in front of your system. You carry the entire world of Unacademy in your pockets in the form of your mobile phone and can access it whenever you want, at whatever convenience you have, at whatever time, whatever place. 24/7 you can access the information and make use of it. You do not really need to wait to get to a class or get home and then start using the thing. And if you have any questions or any issues while downloading the Unacademy Learning app, you can always chat with us and try and clear all your doubts. The chat with us window is given here, so you can chat with us and make the most of it. So once again, thank you for being a part of Unacademy Learning app. For the people who have downloaded it, and for the ones who have not yet downloaded it and not using it, I request you to download it and use it as soon as possible. Now let's come to the various packages that Unacademy has to provide. Like I told you, the Unacademy Plus platform is a paid subscription platform which provides you various packages. And as I'm part of the CA Foundation and Intermediate subscription, given below are the various packages under the CA Foundation and Intermediate subscription of the Plus platform of Unacademy. Firstly, the package is for 1 month, like you can see. The price per month is rupees 3150. Then you have the 3-month package, which costs rupees 8750. Third, you have the 6-month package, which costs rupees 14,000. Then you have the 12-month package, which costs rupees 17,500. And lastly, you have the 24-month package, which costs rupees 21,000. So while you are free to choose the package of your choice as per your requirement, I would strongly urge you or encourage you to use the 12-month subscription or the 24-month subscription for 2 reasons. Firstly, it is cost effective. If you see the per month cost of the 1-month subscription, and if you see the per month cost of the 12-month subscription and the 24-month subscription, you can see there is a major difference in the per month cost. Okay, so the first reason is it is cost effective. The second is that when you prepare for your CA Foundation and Intermediate examination, you normally require a year or 20 or more than that to prepare for both the foundation and the intermediate subscription. And both these packages, the CA Foundation and the Intermediate, is being given to you under one package. That is for 1 month, 3 months, 6 months, 12 months and 24 months. And that is the simple reason I request you, or I urge you, to go for the 12 months or the 24 months package, as the case may be. Now, while you decide to go for the package of your choice, please do not forget to use the code Prathik, that is PRATHIK, to get a discount of 10% on the listed price. So I repeat, PRATHIK, to get a discount of 10% on the listed price of the subscription. So the after discount price of the various subscription packages provided by the Plus platform of Unacademy are: the 1 month package will cost you rupees 3150, the 3 months package will cost you rupees 7875, the 6 month package will cost you rupees 12,600, and the 12 months package will cost you rupees 15,750, and the 24 month package will cost you rupees 18,900. So you see, when you use the code Prathik, you immediately get a discount. You immediately get a discount of 10% on the listed price, and your price falls substantially. So please make a wise choice. I personally recommend you to go for the 12 months or 24 months package to get a discount, and to get a discount of 10% on the listed price, I request you to use the code Prathik when you decide to pay. And having said this, you are free to choose any package of your choice, be it the 1 month, be it the 3 month, be it the 6 months, 12 months or 24 months, while my personal recommendation will be the 12 months or the 24 months package. So I look forward to seeing you all on the Plus platform of Unacademy very soon. All right. Now, for the people who are attending my session for the first time, I have taken sessions on various topics on the Companies Act and other laws for CA Foundation and CA Intermediate, and all of them are posted on the YouTube channel as well as in the Unacademy app. I request you all to go to the YouTube platform and look for Prathik, that is Prathik Gupta, and view my videos and like and review them, and in case you like them, and I hope you find all these sessions useful. Also, there are various other sessions on the Unacademy app which you can access it and make use of it at whenever you want at your convenience. And for the ones who have not yet followed my profile, I request you to go to the Unacademy app, go to my profile, that is Prathik Gupta, Prathik, and click on the follow button to get real-time updates about the timings and the topics of my sessions, so that you don't miss them and are always on time for my sessions. Okay, so let's proceed. Now, the topic that we're going to take in today is incorporation of company and matters matters incidental thereto, part 2. Now, why do I say part 2? Part 2 because part 1 has already been taken and it is present in on the YouTube channel under my name. So please look for Prathik Gupta and go and look for Incorporation of Companies and Matters Incidental Thereto, Part 1, which covers the introduction of Companies Act 2013 to the CA intermediate students, and also who want to know a little bit more about the Companies Act 2013. So please go there and look at Part 1, where everything is explained in detail, and then we are continuing with Part 2. But having said this, do not worry for the people who have not attended my Part 1. I will be quickly recapping Part 1 as well today, so that you follow what we are doing in today's session as well. It will be a little faster than what I did in Part 1 because obviously we are recapping it and it's a repeat of what we've done already. So I would request you to go to Part 1 on YouTube and view that topic, and so that it makes more sense to you, and then we come back here and look at Part 2. So please stay tuned as we will do a quick recap about Incorporation of Companies and Matters Incidental Thereto. So before we start off, I mean, what do you mean by incorporation of companies and matters thereto? Like we spoke, incorporation of a company can be either a private limited or public limited company, and it has to be incorporated under the Companies Act 2013. Earlier to Companies Act 2013, we had Companies Act 1956, and before that we had another Companies Act. So any company incorporated under any of these Companies Act will be governed or administered by the Companies Act 2013. So we spoke about the various types of companies, the various documents of a company like Memorandum of Association and Articles of Association. And today also we will be talking about the concluding part of this topic of incorporation of company and matters incidental thereto. So let's start off. I will be a little quick for the recap session. So in case you have any questions at any point, please ask me. Okay, now incorporation of companies. A company is a separate legal entity with perpetual succession for lawful purpose. So once a company comes into existence, it becomes a separate legal entity. So this is one of the main characteristics of a company, and also perpetual succession. Separate legal entity means it is a separate legal entity distinct from its members or board of directors or everyone, and it is a separate SC under the eyes of the law. And also perpetual succession. Perpetual succession simply means that the directors or members of the company may come and go, but a company will not die until it is officially wound up by the company following the procedures. Okay, so development of this concept is equally significant in economic terms as invention of steam engine is for the Industrial Revolution. So the introduction of companies or the Companies Act was as good as introduction of steam engine, because it gave an opportunity for people to start off their own businesses with limited liability and to carry on the work. People who initiate the promotion of a company are known as promoters. All the persons who take steps for the registration of the company, that is associated with the preparation of a prospectus or in drawing up of the memorandum of the company or assisting in registration, are known as promoters. So promoters simply mean the people who are involved in bringing the company into existence or drafting of the memorandum and assisting in the registration of the company. Formation of a company. The Companies Act 2013 deals with the basic requirement with respect to the constitution of the company. In the case of a public company with or without limited liability, any 7 or more members or more persons can form a company for any lawful purpose by subscribing their names to the memorandum and complying with the requirements of this act. in exactly the same way, two or more persons can form a private limited companies. Please excuse my drawing lines. They're not really straight because I'm using a tab. So kindly excuse, I'm just trying to highlight the important points there. All right. So this slide simply says that 7 or more persons can come together and form a public limited company, whereas 2 or more persons can form a private limited company. And one person, even this is an important concept, which is started by the Companies Act 2013, where it allows you to start a company with one person. That is called a one-person company, or OPC. So a public limited company shall have a minimum of 7 or more members. Private limited company will have a minimum of 2 or more members, and OPC, a one-person company, will have a minimum of we will have a minimum and maximum of one person to start a company. All right. Now, a company may be formed. Now we look at characteristics of the company. A company may be formed for any lawful purpose by 7 or more persons, where the company is to be formed a public limited company. By 2 or more persons, where the company to be formed is a private limited company, and 1 person, where the company to be formed is a one-person company. We saw this in the previous slide. Provided also that it shall be the duty of the member of one-person company to intimate the company the change, if any, in the name of the other person nominated by him, in indicating in the memorandum or otherwise in such time. So this also means in a one-person company, as the company has only one member, it is the duty of that one member to nominate a person. In case something happens to him, then that person who has been nominated can replace him in managing the company. Okay, and if there is any change, if the original member of the one-person company wants to change such a nomination, he has the right, and he has to intimate the registrar within such time as may be prescribed. Also, the person who has been nominated has the right to either accept the nomination or reject the nomination and say that no, I do not accept the nomination, and please select someone else. Okay. Maintain minimum number of members. Section 3A. If at any time the number of members of a company is reduced, in the case of a public limited company, that is below 7. In the case of a private limited company, below 2, and the company carries on business for more than 6 months while the number of members is so reduced, every person who is a member of the company during that time that it so carries on business after the expiry of 6 months and is aware of the fact that it is carrying on business with less than 7 or 2 members, as the case may be severally liable for punishment for the payment of whole debts of the company contracted during the time. So now this simply means the minimum number of members in a public limited company is 7, whereas the minimum number of members in a private limited company is 2. So the company needs to have these minimum number of members. So in case the number of members of a private limited company falls below 2 and it falls below 7 in case of a public limited company, and the company carries on business for a period of 6 months, and the other members of the company know this fact that the number of members has fallen below 7 in case of a public and fallen below 2 in case of a private limited company, and then all the members who are aware, the case shall be liable for the debts of the company contracted at time. So after 6 months, whatever the debts of the company are, the members who know that the company worked for a period of 6 months with the number of members reduced below 7 and 2, they shall be liable for the debts. Okay. So the important part is 7 and 2. All right. The number of members should not fall below 7 in case of public limited company and should not fall below 2 in case of private limited company. Incorporation of a company. Now let's go to incorporation of a company. Incorporation. The Companies Act 2013 provides for the procedure to be followed for incorporation of a company. Now we go to the steps for incorporation. Firstly, we need to reserve the name by filing an e-application. Please remember that the company, a private limited or a public limited company or an OPC cannot have any name they want. The name should be allowed by the registrar of companies. That is, it should not be similar to a existing company. It should not carry offensive names. It should not carry restricted names and all that. Only then will the registrar of companies allow that name to be accepted. So first step is you need to apply for the reservation of name. You need to give 6 names in order of preference, and also the meaning of the names if they are given in any other language. Then the registrar of companies checks his internal records, and if he finds it okay, will approve the reservation of name. All right. Then the second step is drafting of and signing of MOA. MOA means Memorandum of Association. Article, and AOA means Articles of Association, and submission to the ROC. ROC is Registrar of Companies. These documents have to be electronically drafted and e-filed and stamped. So the memorandum and articles have to be prepared with all the clauses and have to be e-verified and e-stamped. Then we come to the consent of the persons nominated as directors. Obviously, there have to be certain directors in the company who run the company. So their consent also has to be electronically submitted in a form that they are willing to be directors of the company. Then we come to submission of statutory declaration, compliance and other declaration. The directors or the members of the company need to sign a declaration that all statutory compliances have been carried out by the company and they are in full compliance of the applicable laws. After all this, you need to pay the fees and the stamp duty, which depends on state to state, and the fees to the MCA, that is the Ministry of Corporate Affairs. They charge you a nominal fee for incorporation of your companies, and then you need to submit the documents. So what are the documents you've submitted? You've submitted the MOA. Okay, you've submitted the MOA and the AOA. Just one sec, I think I'm facing a problem with pointing. Okay, and then you also submit the consent of directors and then the statutory compliance, this thing, and then you pay the fees. Then once you have submitted all the documents and all the documents are found to be okay, then the ROC will obtain, then the ROC will issue a certificate of incorporation digitally signed by the ROC of the particular state in which you have applied, and then you need to file a declaration for the registered office of the company. Normally the registered office of the company is also done along with the incorporation procedure, but the MCA gives you a right that after the incorporation you can intimate to the registrar of companies about the registered office of the company. All right, so these are the steps that need to be done for incorporation of a company. So again, to quickly recap, what are the steps for incorporation of a company? Filing of documents and information with registrar, issue of certificate of incorporation or registration, and once you get a certificate of incorporation, it contains a number known as corporate identity number. That corporate identity number is unique to that company. Then once your company comes into existence, you need to maintain copies of all documents and information and furnish of false or incorrect information. Furnishing of false or incorrect information or suppression of material facts at the time of incorporation will lead to penalties and severe punishments. Company already incorporated by furnishing any false or incorrect information or representing any material fact, the company may strike down or cancel the incorporation of the company and refer the company to the tribunal, and the tribunal's order will be final. The tribunal might levy, tribunal means company law tribunal, might levy heavy penalties and fines for incorporating a company using fraudulent means and methods. So this does not have to be done. You do not need to use fraudulent means. It has to be accurate and correct means. Okay. Then incorporation of a one-person company. How do you incorporate? Now we are talking about incorporation of one-person company. The law with respect to formation of an OPC provides that the memorandum of the OPC shall indicate the name of the other person who shall, in the event of subscriber's death or his incapacity to contract, become the member of the company. Like I told you, an OPC has just one person. So in case the memorandum of the OPC will carry the nomination of that one person. In case something happens to the subscriber, then that other person can carry over the operations of the company. Now, such other person may be given the right to withdraw his consent. I already told you about this. Such other person may or may not give his consent. If he says, okay, I will act, I will take care of the company, something happens to you, then he's given his consent. But in case he says, no, I'm not agreeing to this nomination, then he will withdraw his consent. The member of OPC may at any time change the name of such other person by giving notice to the company, and the company shall intimate the same to the registrar. Any such change in the name of the person shall not deem to be an alteration of the memorandum. So similarly, like I told you, if the person who's been nominated has the right to withdraw his consent, the person giving the nomination also has a right to change that person, the nominated person, and he can alter the memorandum. Then the natural person shall not be a member of more than one OPC at any point in time, and the said person shall not be a nominee of more than one OPC. So only if a person is a subscriber or a member of one OPC, he shall not be a member of another OPC at the same time. Similarly, he shall not be a nominee. He shall not be a nominee of more than one OPC at the same time. I have discussed all this more in detail in part 1. So I request you to go through that again, and I'm going a little quickly on this because I'm recapping what we've done already in part 1. Then now this one is very important. Now we have formation of companies with charitable objects. These are known as Section 8 companies in the Companies Act 2013. Now these are basically prepared or incorporated with the objects of charitable objects and etc., and not for profit making. So the object of formation of Section 8 company is Section 8 of the Companies Act 2013 deals with the formation of companies which are formed to promote the charitable objects of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment. Such companies intend to apply its profit in promoting its objects and prohibiting the payment of dividend to its members. That means whatever money they get or whatever profit they make has to be used again for the objects and not to be distributed as dividends among its members. The power of the central government. So we've seen the objects. Now the power of the central government to issue the license. So once a company under Section 8 has to be incorporated, we need to take the permission of the central government. This section allows the central government to register such person or association of person as company with limited liability without the addition of the words limited or private limited by issuing a license. So if the central government is convinced that this company is a Section 8 company, it may allow or give permission to the company to be incorporated without using the terms private limited or public limited company. Okay, now what are the privileges of limited liability? A Section 8 company has the privilege of limited liability, which is one of the most important privileges of a company under the Companies Act 2013. Limited liability means the liability of the members of a company is limited to the extent as disclosed or committed by them, and their personal assets cannot be touched in case the company fails to repay its debts to the vendors. Okay, so this particular quality or feature is available even for a Section 8 company. Okay, a firm. Then lastly, a firm may be a member of a company registered under Section 8. That is, a partnership firm can also become a member of a company registered under Section 8. Then we look at alteration in Memorandum of Articles. A company registered under this section shall not alter the provision of its memorandum or articles except with the previous approval of central government. So, like a central government has given its approval and only then a license is issued to a Section 8 company. If the Section 8 company intends to alter its memorandum or articles of association, it needs the previous approval of the central government, and only then can it amend its articles or memorandum of association. And then we have the revocation of license. The central government may, by order, revoke means cancel the license of a company where the company contravenes any of the requirements or the conditions of this section subject to which a license is issued, or where the affairs of the company are conducted fraudulently or violation of the objects of the company or prejudicial to the public interest. So in case the whole purpose or object for which the company was created and a license was issued by the central government, if that object is not carried on by the company, that means it does not use the money for the purpose of religion, education, society as it committed, or the operations of the company are fraudulent. In that case, the central government has the whole right to cancel the license given to it earlier, and then it becomes a normal company and all its profits are taxed, and all the provisions of a private limited and public limited company become applicable to such a company. Okay. Now, what is the effect of registration? According to section 9, from the date of incorporation, that is the date mentioned in the certificate of incorporation, the subscribers to the memorandum and all other persons who may from time to time become members of the company shall be a body corporate by the name contained in the memorandum. Then such a registered company shall be capable of exercising all the functions of an incorporated company under this act, and having perpetual succession with the power to acquire, hold and dispose of property, both movable and immovable, tangible or intangible, to contract and sue and to be sued. So once a company is incorporated, it shall become a body corporate, and also it shall be a company with perpetual succession, and such company will have the power to enter into contracts, hold assets, both tangible and intangible, as well as movable and immovable, and to sue and to be sued. Please take about 30 seconds, go through this slide, and then we proceed. Okay, now we go to the Memorandum of Association. This is a very important topic because the Memorandum of Association is a very important document for a company. Let it be a private limited company, a public limited company, one-person company, Section 8 company, or any kind of company incorporated under the Companies Act 2013. So, like I'm saying, a Memorandum of Association is very important. Okay, it is the base document for the formation of a company, and along with the Articles of Association is regarded as the constitution of the company. Just like we have the Constitution of India, which contains the rights and obligations of each citizen of the country, we also have the Memorandum and Articles of Association of a company, which are regarded as the constitution of the company. So what are the clauses of a Memorandum of Association? The object clause. The object of registering a Memorandum of Association. It contains the object for which a company is formed, and therefore identifies the possible scope of its operations beyond which its actions cannot go. So one of the main purposes of the Memorandum of Association is it gives the main objects or purposes for which a company is incorporated, and basically a company cannot carry on any other objectives or activities beyond what is mentioned in its memorandum. Okay, so then it enables the shareholders, creditors, and those who deal with the company to know what its powers are and what activities it can engage in. So whoever is dealing with the company, for example, the shareholders, the creditors, and those who deal with the company, like your investors, the government, it can clearly know what are the activities the company can do and what are the activities the company cannot do. A memorandum is a public document under Section 399 of the Companies Act. Consequently, every person entering into a contract with the company is presumed to have knowledge of the conditions contained therein. So like I told you, a Memorandum of Association carries the basic objectives of a company or the basic activities that the company intends to carry out. And it is a public document. By meaning public document is anyone can pay a fee to the ROC or to the company and obtain a copy of the Memorandum and Articles of the company. So they cannot later on use an excuse that they did not get a copy of the Memorandum of Articles of Association, and they are supposed to know, because these are public documents, they are supposed to collect the documents and read the MOA and AOA of the company. Then the stakeholders must know the purpose for which the money is used by the company and what risk it's taking. So once the objective clause of the Memorandum of Association is dealt with, it contains the basic objectives. So once a person decides to invest in a company, he would have a clear idea where his money is going to be used and what are the activities for which his money is going to be used. And if there is any activity which is unlawful or doubtful contained in the Memorandum of Association, then the shareholder might decide not to invest his money. So basically it gives information to all the relevant stakeholders about the objectives of the company. Okay, the Memorandum of a company shall state, so basically a Memorandum of Association of a company shall have the following 6 clauses. First one, in relation to the name clause, the Memorandum of Association will clearly mention the name of the company, that is ABC Private Limited or ABC Limited or simply ABC if it is a Section 8 company, or if it is a OPC, it will say ABC Private Limited in brackets OPC. Okay, in relation to the registered office, the Memorandum of Association will give the registered office address of the company and the state in which the registered office of the company is located. Most importantly, it will give you the objects of the company. That is, what is the main activity that the company intends to carry out through its incorporation. And it contains those object clause. Okay, so the main activities of the company are contained in the object clause, and the company is supposed to only carry out those objects and not any other activities which are beyond the memorandum. Otherwise, it will be termed as ultra vires the memorandum of association. Fourthly, we have the liability clause, which simply says whether the liability of the members is limited or unlimited, or it is limited by shares or limited by guarantee. Then we have the capital clause, which simply gives the details of the authorized capital of the company. That is, if it is 20 lakh rupees divided by 2 lakh shares of rupees 10 each, this clause will say that. And lastly, and most importantly, it will have the subscription clause, where the subscribers to the memorandum of association give their undertaking that they are ready to take the number of shares given against their names, and they sign against it. So these are all the contents of the memorandum of association. Now, if you quickly go through this, the Companies Act 2013 gives you various model memorandum of associations and model articles of associations. You are free to prepare a memorandum and articles right from the beginning, but to help you, there are various models given, and you can accept these models after making minor changes or accept them as it is. So let's go through them quickly. Table A gives you the memorandum of association of a company limited by shares. Table B gives you a memorandum of association of a company limited by guarantee and not having a share capital. Table C gives you memorandum of association of a company limited by guarantee and having a share capital. Table D gives you a memorandum of association of an unlimited company and not having a share capital. Table E gives you the memorandum of association of an unlimited company and having a share capital. Table F gives you the articles of association of a company limited by shares. Table G gives you the articles of association of a company limited by guarantee and having a share capital. Table H gives you the articles of association of a company limited by guarantee and not having a share capital. Table I gives you the articles of association of an unlimited company and having a share capital. And lastly, Table J gives you the articles of association of an unlimited company and not having a share capital. So whatever the kind of company you're incorporating among these from A to J, you can look at the model articles of association and pick out the clauses that you want, or accept the model articles of association as it is. I have explained more of this in detail in part 1. So please go through part 1 of Incorporation of Companies and Matters Incidental Thereof and let me know. Articles of association. Articles mean the articles of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law. This thing. Actually, articles of association contains internal rules and regulations of the company. So the memorandum of association contains the external relationship of a company, whereas an articles of association contains the internal rules and regulations of the company. So let's look at what it talks about. First, it contains the regulations. The articles of a company shall contain the regulations for the management of the company, that to the internal rules and the procedures of the company, that to how the company should be done, how to conduct meetings, how to appoint directors, how to remove directors, how to appoint auditors, how to remove auditors. These are few of the procedures that the company it will give you in the articles of association. Inclusion of matters. The article shall also contain such matters as prescribed under the rules. Entrenchment. Usually an article of association may be altered by passing a resolution, special resolution, but entrenchment makes it more difficult to change it. So entrenchment means making something more protective. So an articles of association is normally protected by the Companies Act and it is not so easy to change it. The forms of articles, like we saw in the previous slide, we have tables F, G, H, I, J in Schedule 1. These are the model articles of association of a company, and a person can use these models while he is preparing an articles of association. Now, please come to the important topic. Now, this is an important topic. What do you mean by Doctrine of Ultrawise? Now, I told you, right, that the main object of a memorandum of association is to spell out or give out the main objectives of the company. So, the meaning of the term ultrawise is simply beyond the powers. The legal phrase ultrawise is applicable only to acts done in excess of the legal powers of the doers. This presupposes that the powers in their nature are limited. It is the fundamental rule of company law that the objects of a company, as stated in the memorandum, can be departed from only to the extent permitted by the Act. Thus far and no further. In consequence, any act done or a contract made by the company which travels beyond the powers, not only the directors but also of the company, is wholly void and inoperative of law, and it is therefore not binding on the company. On this account, a company can be restrained from employing its fund for purposes other than those sanctioned by the memorandum. Likewise, it can be restrained from carrying on trade. So this simply means whatever are the activities and the objectives that are given in the memorandum of association, only those activities and objectives can be carried on by the company. And if a company carries on any other objectives beyond what is mentioned in the memorandum of the company, it is completely void, and the person who has carried out the transaction can ask for a compensation or ask for the contract to be cancelled. Let's look for an example. If you have supplied goods or performed services on such contract or lent money, you cannot obtain payment or recover the money lent. But if the money advanced to the company has not been expended, the lender may stop the company from parting with it by means of an injunction. This is because the company does not become the owner of the property. As the lender becomes, so this simply means if the company does not have the activity of lending money, or it carries on an act which is beyond the memorandum of association, in that case, that particular activity is void and the contract is void. Now, also let's come to the doctrine of indoor management, which is again an important topic. So Ultrawise and Doctrine of Indoor Management. Now, like I told you, the memorandum of association and the articles of association are public documents. That means a person can pay a fixed small fee and obtain these documents before he enters into a transaction with that person. So later on, the person cannot use the excuse that he did not have the memorandum or he did not have the articles of association, because those were available as public documents and he could have obtained it by paying a small fee. Okay, so let's read the doctrine of indoor management. According to this doctrine, a person dealing with the company cannot be assumed to have knowledge of the internal problems of the company. He can simply assume that all the required things were done properly in the company. Okay, the doctrine helps to protect the external members from the company and states that the people are entitled to presume that internal proceedings are as per the documents submitted to the registrar of companies. Now, like I told you, the articles of association gives you the details of the internal procedures of the company. So anyone who's dealing with the company need not have to doubt that the internal procedures of the company are not being carried out properly, or there is some problem with the internal management of the company, unless he has a reason to believe so. So he can very well go ahead and work with the company. Stakeholders need not inquire whether the necessary meeting was convened and held properly or whether necessary resolution was passed properly. They are entitled to take it for granted that the company had gone through all these proceedings, like for example, conduct of meetings, forum for the meetings. So a person dealing, like example, you are a vendor, you're selling something to the company. You really need not worry about these things, that whether the meetings have been conducted properly, whether everything else has been done properly, because those are all internal procedures of the company, and you will not know it, right? Because obviously you will not be part of those meetings. So those are presumed by you to be done by the company on time. The doctrine of indoor management evolved about 150 years ago in the context of the doctrine of constructive notice. The role of doctrine of indoor management is opposed to of the role of doctrine of constructive notice. Whereas the doctrine of constructive notice protects a company against the outsiders, the doctrine of indoor management protects outsiders against the actions of the company. The doctrine also is a possible safeguard against the possibility of abusing the doctrine of constructive notice. Now they have spoken about two concepts here. One is the doctrine of indoor management and one is the doctrine of constructive notice. Now, constructive notice simply means that the person has knowledge about the contents of the articles of association and the memorandum of association, as those are public documents. So he can pay a small fee and he can read those documents. Later on, he cannot say that I did not know it. But whereas the doctrine of indoor management simply means even though he had the memorandum of association and the articles of association with him, he need not worry about the internal procedures of the company and whether those have been conducted, whether the company has passed a special resolution, whether the company has done the filing with the ROC, whether the company has conducted the meeting properly. All those are not his problem and the company needs to take care of it. Basis for doctrine of indoor management. what happens internally to a company is not the matter of public knowledge. An outsider can only presume that the intention of the company not known by the information he is to privy. Like I said, whether the company has conducted the meetings or not, he will not know. He will only know whether his contract is approved and whether he gets his payment. If not for this doctrine, the company could escape creditors by denying the authority of officials to act on its behalf. If there was no doctrine of indoor management, then it was very easy for the directors of the company and other officials to cheat the vendors, right? They will say, no, the meeting was not held properly, so it was an invalid resolution, so we will not pay you money. So to protect the interest of the people dealing with the company, the doctrine of indoor management was introduced. Exceptions to the doctrine of indoor management. Now, even though indoor management doctrine is there, but it has got certain exceptions. What are the exceptions? Knowledge of irregularity. If the outsider dealing with the company already had knowledge about the irregularities in the internal proceedings of the company, then later on he cannot say that no, it was a doctrine of indoor management and I am not supposed to know. If he had knowledge of the irregularity. Negligence. If with minimum effort the irregularities within the company could be discovered, the benefit of the rule of indoor management will not apply. The protection of the rule is also not available where the circumstances company does not take proper inquiry. So anyone dealing with the company, if he could have used a little bit of efforts and found out whether the internal procedures of the company are followed or not, and he didn't do so, then he cannot take advantage of the doctrine of indoor management. And lastly, forgery. The rule does not apply where a person relies upon a document that turns out to be a forged one, since nothing can validate forgery. A company can never be held bound for forgeries committed by its officers. Now, forgery simply means doing something by fraud or obtaining consent by fraud. So if there was anything that a company has done by forgery or copying someone else's signature or authorization, then that particular contract is void in all cases, and no doctrine of indoor management can validate this. It is a complete no-no and it is void. Okay, so what are the exceptions of doctrine of indoor management? It is known irregularities, negligence and forgery. Now, act to override memorandum and articles of association. Now, what does this mean? The Companies Act 2013 will override the provision of memorandum and articles as long as they are in contrast and unlawful to the extent of Companies Act 2013. So, according to Section 6 of the Act, save as otherwise expressly provided in this Act, the provision of this Act shall have effect notwithstanding anything to the contrary contained in the memorandum or articles of the company, or in any agreement executed by it, or in any resolution passed by the company in general meeting or by its board of directors, whether the same be registered, executed or passed, as the case may be, before or after commencement of the act. So if there is anything, any provision or any act done by the company, either by the board of directors or by special resolution or by normal ordinary resolution, if any act is done which is contrary to the provisions of the Companies Act 2013, then the provisions of the Companies Act 2013 will prevail, and those clauses of the memorandum and articles of association cannot hold good. Like, for example, I told you the minimum number of members is 7 in case of public limited company and 2 in case of private limited company. So let's say the company in its articles of association puts a clause that the company can continue to work even though the number of members fall below 7 in case of a public limited company. In that case, that particular clause will not be acceptable because it is contradicting to the Companies Act 2013, and the provisions of the Companies Act 2013 will prevail. Any provision contained in the memorandum, articles, agreement or resolution to the extent which is repugnant or in conflict to the provisions of this act become or be void, as the case may be. In simple words, the provision of this act shall have overriding effect. But keep in mind that this section starts with save as otherwise. It means that if any other section of the act says that the article is superior, then we will treat accordingly. So if any provision of the memorandum of articles is in conflict or is contradicting with the Companies Act, then the provisions of the Companies Act 2013 will prevail. Now, what happens to the when the memorandum and articles of the association are registered. Now, subject to the provision of this act, the memorandum and articles shall, when registered, bind the company and the members thereof to the same extent as if they were respectively have been signed by the company and by each member, and contained covenants on its and his part to observe all the provision of the memorandum and of the articles. It means that on the basis of MOA and AOA. So what happens once the memorandum of association and articles of association are started off? It simply means that it binds the company and the subscribers to the memorandum and articles of association to each other, and whatever is mentioned in the memorandum and articles of association is supposed to be done by the members or the subscribers and the company. So it simply means that on the basis of MOA and AOA, the company is liable to its members, the members are liable to the company, but normally members are not liable to each other. So once a memorandum of association is registered and the articles is registered, the company becomes liable to its members. The members are liable to the company for any acts done by negligence or against the interest of the company, but never are the members liable to each other. So either the member is liable to the company or the company is liable to the members, but never are the members liable to each other. All the money is payable by any member to the company under the memorandum of articles shall be a debt due from him to the company. So let's say the subscribers A and B undertake to subscribe 5,000 shares of the company. All right. So they say that yes, we will take up 5,000 shares of rupees 10 each and we will pay the money. So until and unless that 5,000 rupees into 10, 50,000 rupees is received from A and B each, it will be considered as a debt due to the company by the subscribers, and the company shall have the right to recover the money whenever it wants. All right, please take about 30 seconds, go through the slide, and then we proceed. Now we look at the alteration of memorandum. Now, memorandum of association is a very important document, and obviously it contains, like I told you, the name clause, the domicile clause, the object clause, the liability clause, the subscription clause, and the share capital clause. So there might be a case where the object clause or the name or the address of the company needs to be altered. So there now we will talk about the provisions that are there for alteration of a memorandum. So let's start off. This is a very important concept, and please ask me any questions you have at any point. Now, firstly, let's look at alteration of the memorandum, alteration by a special resolution. A company may alter the provisions of the memorandum with the approval of the members by a special resolution. So normally, if a memorandum of association has to be altered, it has to be altered by a special resolution by its members. Okay. Then the name change of the company. Any change in the name of the company shall be effected only with the approval of the central government. Let's say if the name of the company has to be changed, then the approval of the central government is required. But if it only involves the removal of the name term private or the addition of the term private in the name of the company, then the approval of the central government is not required. It can be done with a special resolution of the members of the company. Then entry in the register of companies. Any change in the name of the company, the registrar shall enter the new name in the register of companies in place of the old name and issue a fresh certificate of incorporation. So let's say a company changes its name from ABC Private Limited to ABCDE Private Limited. Then it passes a special resolution and files the necessary forms with the registrar of company, and then the registrar of companies enters such a changed name in the register of members, and then issues a new certificate of incorporation with the new name of the company. Change in the registered office of the company. The alteration of the memorandum relating to place of the registered office from one state to another will not have effect unless it is approved by the central government. So please remember, if the registered office of the company needs to be changed within the state, that means within Karnataka, if the office has to be changed from one place to the other, a special resolution is enough. But in case the registered office of the company needs to be changed from Karnataka to Maharashtra, In that case, the approval of the central government is necessary along with the special resolution. Only then can the registered office of the company be changed. Filing with the registrar. A company shall, in relation to the alteration of memorandum, file with the registrar the special resolution passed by the company, the approval of the central government, and if the alteration involves in any change of the company. So, whenever the company wishes to change the address of the company or the name of the company, it shall file with the special resolution along with the approval of the central government with the registrar of companies, and only then the registrar of companies will make the changes in the register of companies and issue a new certificate of incorporation. Alright, so this is the alteration of memorandum. Then, filing of the certified copy of the order with the registrar of states, where alteration of the memorandum results in transfer of the registered office of a company from one state to another. A certified copy of the order of the central government approving the alteration shall be filed with the registrar of each state. So let's say the registered office of the company is being shifted from Karnataka to Maharashtra. Then in that case, firstly you need to apply for the approval of the central government, and then that approval of the central government has to be filed in both the states, that is in Karnataka as well as Maharashtra, in order for that change to take place. Then once the registrar of companies is satisfied about the change, he will issue a new certificate of incorporation. The registrar of the state where the registered office of the company is being shifted to shall issue a fresh certificate of incorporation indicating the alteration. Now we come to change in the object clause of the company. A company which has raised money from the public through prospectus and still has any unutilized amount out of the money so raised shall not change its objectives for which it raised money through prospectus unless a special resolution through postal ballot is passed by the company. So let's say a company wishes to change its objectives. Then in that case, it can change the objectives only by a special resolution of the members of the company is passed, and then the details in respect of such resolution also be published in the newspaper. So once a special resolution has been passed for alteration of the object clause of the memorandum, that resolution has to be printed in two newspapers, one in a local paper in the local language of the state in which the registered office of the company is situated, and also in one English newspaper in wide circulation in that area. So they need to put that resolution. The dissenting shareholder shall be given an opportunity to exit by the promoters, and the shareholders having control in accordance with the regulations be specified by the Securities Exchange of Board of India. Now, like I told you, the special resolution. What do you mean by special resolution and ordinary resolution? An ordinary resolution is a resolution passed by the majority of the members present in a meeting and voting. Whereas a special resolution is a resolution passed by at least 3/4 of the members present in a meeting and voting. So obviously if it's 3/4, then there is a chance that 1/4 of the members do not vote in that favor, right? So in case 1/4 of those members or less do not vote in favor of changing the objectives of the company, then those members will be given an option to leave the company by the promoters and shareholders in accordance with the rules and regulations of SEBI and Companies Act 2013. Okay. Registrar to certify the registration or the alteration of articles. Objects. The registrar shall register any alteration on the memorandum with respect to the objects of the company and certify the registration within a period of 30 days from the date of filing special resolution. So once the company decides to change its objectives and files the special resolution with the registrar within 30 days of filing such a special resolution shall make note of such changes. Alteration to be registered. No alteration made under this section shall have any effect unless it has been registered in accordance with the provision of this section. Only members have the right to participate in the divisible profits of the company. An alteration of the memorandum in case of a company limited by guarantee and not having a share capital, intending to give any person a right to participate in the divisible profits of the companies, otherwise a member shall be void. Okay, now this is not an important clause. We'll discuss about it in future. Now we go to alteration of articles. Similarly, how we alter the memorandum of association, even your articles of association can be altered. On alteration by special resolution, subject to the provisions of this act and the conditions contained in its memorandum, if any, a company may, by special resolution again, alter its articles of association. So what do we see here? A memorandum can be altered by a special resolution, as well as an article of association can also be altered by a special resolution. Alteration to include conversion of companies. Alteration of articles include alterations having the effect of conversion of a private limited company into a public limited company, a public limited company into a private limited company. So once you alter an articles of association of the company, the alteration can also be made in order to convert a private limited company to public limited company, or a public limited company to a private limited company. If you go through my part 1 of the session, there are 3 important clauses contained in the articles of association of a private limited company that distinguish it from a public limited company. The 3 clauses are restriction on the maximum number of members, restriction on the transferability of shares of a private limited company, and restriction on invitation to public to subscribe to the shares of the company. A private limited company cannot have all these 3, whereas a public limited can have these 3. So once these 3 clauses are removed from the articles of association, then the private limited company becomes a public limited company. Okay. Then, so in case your articles of association is altered for that, then it can also convert a public limited into private, or a private limited company into public. Filing of alteration with the registrar. Every alteration of the articles and a copy of the order of the central government approving the alteration shall be filed with the registrar. Similarly, like your memorandum of association, a copy of the special resolution and the copy of the central government approval shall be filed with the registrar of companies in order to give effect to the alteration of articles. Any alteration made shall be valid. Any alteration of the articles registered as above shall, subject to the provisions of the Act, be valid as if they were originally contained in the article. So if the above procedure of special resolution, approval of central government is all carried out, and then the filing is done with the registrar of companies in time, it shall be assumed to be a valid alteration in the articles of association. Copies of memorandum articles to be given to members. Now, according to section 17, every company, on being so requested by a member, shall send copies of the following documents within 7 days. So any member of the company can make a request to the company for the following documents, and it shall be sent to them within 7 days on the payment of fees. That is the memorandum of association, the articles of association, and every agreement. One is your memorandum, your articles, and then every agreement and every resolution referred to in section 117, resolutions and agreements to be filed if and in so far they have not been embodied in the memorandums and articles. Okay, so these 3 documents, any member of your company can ask for these on payment of fees, and within 7 days from the payment of fees, the company is supposed to send them these documents. In case of default, the company and every officer shall be liable for each default to a penalty of 1000 rupees for each day during which the default continues, or rupees 1 lakh, whichever is less. So just in case the company conducts a default in sending the copies, then the penalty is 1000 rupees per day, or up to rupees 1 lakh, whichever is less. So with this, I come to the end of the incorporation of the company and matters incidental part 2. Part 1 is already contained therein in the YouTube channel. So I request you to go to the YouTube channel, look for my profile Prathik Gupta, Prathik, and go through part 1 in detail. So while you also do this, I would like to bring your attention to a certain matters. The Plus program of Unacademy, Plus platform of Unacademy, is a subscription based model which gives you the following benefits. It gives you daily live classes where you get to chat with your educator, engage in discussions, ask your doubts and answer polls. Yes, all this while the classes are going on. You do not need to wait for an appointment. You do not need to wait for a day to clear your doubts. You can do all this on a real-time basis when the classes are going on. You can choose your educator, you can choose your topic, and attend the daily live classes and clear your doubts as and when they happen. The Plus platform of Unacademy also conducts various live tests and quizzes which help you evaluate your preparation with the regular mock tests and quizzes and get detailed analysis of your performance, so that you identify your strong areas and your weak areas and spend more time on your weak areas and less time on your strong areas. The courses provided by the Plus platform of Unacademy are structured courses in such a way that each course is in line with your exam syllabus to help you best prepare for it, and best efforts are made to ensure that you do not miss any important topics of the syllabus while preparing for the same. And lastly and most importantly, you get unlimited access. One subscription to the Plus platform of Unacademy gives you access to all the live and recorded courses, resources, and content of Unacademy to watch from at the comfort of your devices at whatever time you want and whatever location you want. So this is one of the major advantage of the Plus platform of Unacademy. So I request you and urge all of you to make use of this and become a part of the Plus platform of Unacademy as soon as possible, and also look at the examination or topics that are relevant to you and become a part of that. For those of you who have downloaded the Unacademy learning app and are using it, I thank you for your support. And for the ones who have not yet downloaded the Unacademy learning app and not using it, I request you to download and use it as soon as possible and register on it using your mobile number, on which you will get an OTP, and you use that OTP and get registered on the Unacademy learning app. You need to download it from your Play Store. So once again, I request you to download the Unacademy learning app and make the most of it and all the benefits that it gives. Like I told you, the Unacademy the Unacademy Plus program gives you the following packages. For the CA Foundation and Intermediate subscription, it gives you a 1 month package, a 3 month package, 6 months, 12 months, and 24 months. The 1 month package costs you rupees 3,500. The 3 months package costs you rupees 8,750. The 6 month package costs you rupees 14,000. The 12 month package costs you rupees 17,500. And the 24 month package costs you rupees 21,000. While you make a choice of the package you want, please do not forget to use the code Prathik, Prathik, to get a discount of 10% on the list price. So the after discount price of the various packages provided by the Plus platform of Unacademy for the CA Foundation and Intermediate subscription are: the 1 month package will cost you rupees 3,150. The 3 month package will cost you rupees 7,875. The 6 month package will cost you rupees 12,600. The 12 month package will cost you rupees 15,750, and the 24 month package will cost you rupees 18,900. While you're free to choose the package that you want, I personally would recommend you to go for the 12 month or 24 month package for reasons such as, firstly, it is cost effective. If you look at the per month cost in the 1 month package and the 12 months and 24 month package, it is almost 1/3 of the 1 month package. And secondly, normally for a foundation and intermediate course of the CA course, you require a year to prepare. So if you're getting both the foundation and the intermediate in one package, it makes sense to go for the 12 months or 24 months package. So please do not forget to use the code Prathik to get a discount of 10% on the listed price. Also, I have conducted various sessions on Companies Act and other laws, which can be found on YouTube and the Unacademy platform. Please go to the YouTube and type Prathik, Prathik Gupta, and you will get a list of all the topics and all the sessions that I've taken. I hope you find them useful and benefit from them. And you can also go to the Unacademy app and look for my profile, Prathik, Prathik Gupta, Gupta, and click on the follow button on my profile to get real-time updates about the timings and the topics of my sessions so that you never miss them. And also you can enjoy and benefit from the various sessions that I have put up in the Unacademy app as well. I thank you all for your support and your patient listening. It was a pleasure to have you as an audience. I look forward to you attending all my future sessions as well, and would be happy to get a feedback from you. Thank you so much, and see you all soon.